पण कोर्टाची पायरी चढू नये या मताची सगळ्यात धरून आपण या कोर्टात बसलेली आहे. मी संयोजकांचे, डॉक्टर संचितींचे आणि आपल्या सगळ्यांचे खूप आभार मानते. त्याचं कारण असं की ह्या सगळ्या पूर्ण प्रोसेसमध्ये इतके डिलिजंट डॉक्टर ज्यांना बरीच लॉची माहिती आहे की कदाचित ती मलाही माहिती नसेल, ती आज मला मिळाली. आणि त्याच्यामुळे मी असं समजते की इतक्या डिलिजंट डॉक्टरवर अशी पाळी कधी येतच नाही. आणि डॉक्टर आणि वकील हे तसे मित्र असतात. फक्त फरक असा आहे की आपला पाहण्याचा भरलेला ग्लास आहे, अर्धा ग्लास आहे की रिकाम्या ग्लासमध्ये हवा आहे, हे जसे 3 कॅटेगरीज करतो तसं आपल्या समाजामध्ये प्रत्येकाचं आपण एक लेबल लावतो आणि त्या लेबलमुळे आपली फार अडचण होते. आज माझी आपल्या सगळ्यांना नम्र विनंती आहे की आज हे जे मॉक ट्रायल हे अगदी प्रिलिमिनरी आहे. त्याचं कारण असं की एक वेळेचं बंधन आहे. आणि दुसरी महत्त्वाची गोष्ट की या मेडिकल लिगल केसेसच्या पलीकडच्या पण आम्ही जेव्हा केसेस सोडवतो तेव्हा वेगळा प्रोसिजर नसतं. सगळ्या ज्युडिशियरीमध्ये प्रोसेस एकच असते, त्याच्यामध्ये काहीही फरक होत नाही. आणि तालुका कोर्टात पण नोटीस लावावीच लागते, डिस्ट्रिक्टला पण लावायला लागते. सुप्रीम कोर्टात जर तुम्हाला अपील व्हायचं असेल किंवा तुमची जर कंप्लेंट असेल तर नोटीस तुम्हाला येते. नोटीस येणे हे जसा प्रकार असतो तसा हा आपला हा सगळा कार्यक्रम आपल्याला एनलाइटन करण्याच्या दृष्टीने खूप चांगला आहे. म्हणून मी डॉक्टर काकडेंचा आणि डॉक्टर संजय सरांच्या आधीच आभार मानते. थँक्यू व्हेरी मच.
Okay, so I will tell you the facts of the case in very brief. The complainant here was Dr. Maya Sarabhai, and she was taking treatment from Dr. Rohini, who will be the respondent in the present case, in the case for her infertility. Now, after 4.5 years, spontaneously she became pregnant, and the pregnancy case was also handled by Dr. Rohini as well. Now, on the morning of June 10, 1999, she was admitted for delivery. Now, on her admittance, she was given IV fluid with 1 ampule of syntocinon for speeding of the delivery. Now, she was not taken care of for the entire day. Now, next day at 2 a.m. she was transferred to the operation theatre where there was an emergency cesarean which was taken place, and a female baby was delivered who they named as Nishtha. Now, the baby cried only after 5 minutes, and it was alleged that it is a case of birth asphyxia and seizures, and her health continued to deteriorate. Now, after 2 years, she had some problems throughout. Now, after 2 years, she was admitted in AIMS, and the doctor said that her persistent seizures are because of the negligence of the doctor during the delivery. That she was given excessive of doses of syntocinon. Sorry if I am producing it wrong. Okay. Then the pediatric neurologist said that because of the excessive doses, there was fetal distress, and opined that the baby will continue to suffer mental disorder till whatever age she lives. And that is what happened, that at the age of, after like 12 years, the baby died, and she died with disabilities and a lot of mental retardation. So Dr. Maya filed a complaint asking for total compensation of 18.5 lakhs plus 50,000 for mental agony plus 25,000 for legal expenses. And she said that you did not take proper care of me during the delivery, which resulted in the birth of an asphyxiated baby. And so now we have the case where both the sides will argue in a mock trial.
First of all, you have to clarify that when you are filing the complaint, what procedure you have to have. And tomorrow also like that, I will tell you that. Whenever you file the complaint with the consumer court or any court, first of all, you have to, when you take the advice, usually we go to the lawyers, and lawyer always asks all the details. He prepares a complaint. At that time, first of all, we have to issue the notice. Other party, we cannot understand what is happening, and that's why proper notice has to be issued. If you are filing complaint in the district court or district consumer forum, 3 sets of or 3 members, and the sets of the complaint depending upon the number of opponents are to be given with the forum. At that time, first you are asked to file complaint, notices are issued, proper authenticated notice हे सर्व झाली आहे किंवा नाही याच्याकरता त्याचा पोस्टिल पुरावा तिथे जोडावा लागतो. इफ इट इज नॉट पॉसिबल तर पेपर डिक्लेरेशन करतात. आणि मला खूप लोक असं विचारतात, आय एम मेकिंग इट इन मराठी बिकॉज, की पेपर डिक्लेरेशन अगदी लहानशा पेपरमध्ये आलं तर आम्हाला कसं कळणार की व्हॉट इज द गरज, त्याची गरजच काय. प्रॉब्लेम आपला असा आहे की आपली जबाबदारी आपण पूर्ण केली किंवा नाही ॲज अ कंप्लेंट हे पाहण्याकरता आपल्याला कंप्लेंटच्या आधी नोटीस देणे गरजेचं आहे सगळ्याच ठिकाणी. आणि जेव्हा आपण नोटीस देतो तेव्हा शॉर्टकट मारण्याकरता की ऑपोनंटला फारसं कळू नये असं जर इच्छा असेल तर लहानशा पेपरमध्ये कुठेतरी कोपऱ्यात ती नोटीस असते. अशी नोटीस व्हॅलिड आहे किंवा नाही हे कोर्ट नाही ठरवू शकत. कोर्ट एवढंच म्हणतं की तुम्ही ती रिसिट त्याच्यावर दाखल केली आहे की आम्ही पेपरचं कटिंग लावायला सांगतो. आता सर्क्युलेशन जर पेपर लहान असेल तर त्या पेपरचं कुणाला कळलं कुणाला नाही कळलं. खरं कायद्याला असं अपेक्षित असतं की नोटीस जेव्हा तुम्ही इश्यू करता तेव्हा अशी पाहिजे की मॅक्सिमम लोकांपर्यंत ती पोहोचावी. त्याचा फायदा असा आहे की जनरली जसं सर्च रिपोर्ट आपण जेव्हा कन्स्ट्रक्शन करता किंवा जेव्हा बिल्डिंगचं कन्स्ट्रक्शन करतात तेव्हा विकत घेतो एखादी प्रॉपर्टी, तेव्हा 30 इयर्स सर्च रिपोर्ट घ्या. आता 30 वर्षाचं काय होणार आहे, मी तर मागच्या वर्षी तर पाहिलं त्यांनी याला विकलं, आपण अगदी सहज बोलतोय. 30 इयर्स सर्च रिपोर्टमध्ये त्यांचे कोण सक्सेशन प्रमाणे सगळे लोक लागले होते किंवा नाही, नाही तर ऑल ऑफ अ सडन 40 वर्षापूर्वीचा कोणीतरी एक अबकड माणूस येतो आणि तो तुम्हाला सांगतो की तुमचं हे नाहीच आहे, माझंच आहे, आणि मग भांडण सुरू होतं. आणि म्हणून नोटीस ही प्रॉपर नोटीस लागणं प्रत्येक कोर्टाकरता प्रत्येक स्टेजवर अत्यंत आवश्यक असतं आणि कंप्लेंटला हे करायलाच पाहिजे. ते झाल्यानंतर एक कंझ्युमर फोरममध्ये ऍडमिशन बोर्ड चालवतात की तुमची ही कंप्लेंट करेक्ट आहे किंवा नाही, म्हणजे असेसमेंट ऑफ दॅट कंप्लेंट करेक्ट आहे की फ्रिव्हलस आहे वगैरे. जर तुम्हाला त्यांना वाटली की ही ऍडमिसेबल आहे तर देन पार्टीज आर सर्व्ड विथ द कॉपीज and opponent is called to defend himself. But to defendant, now defendant will. Oh, sir, complainant.
The counsel on behalf of the complainant, Dr. Maya Sarabhai, in the present case of Dr. Maya Sarabhai versus Munich Hospital and others. In the present case, the 15 days notice was issued on 29th of January 2015 and all relevant documents have already been furnished to the opposite parties in the forum. The council seeks permission to state the jurisdiction in the present case. The District Consumer Disputes Redressal Forum has the jurisdiction under Section 11 of the Consumer Protection Act 1986. The council seeks permission to proceed with the arguments. In the present case, the council humbly submits before the forum that there was medical negligence on the part of the respondent number 2, Dr. Rohini Lodha, practicing gynecologist and infertility specialist at Munich Hospital, which is vicariously liable. There was medical negligence as there was a duty of care as the services of gynecologist and infertility expert Dr. Rohini Lodha and the Munich Hospital were sought and due payment was made for the same. Secondly, there was breach of this duty of care. Third, hence the resulting damage. On the Honorable Supreme Court in Kusum Sharma and others versus Batra Hospital and Medical Research Center and others held that if a doctor does not adopt proper procedure in treating his patient and does not exhibit the reasonable skill, he can be held liable for medical negligence. In order to prove the same, the council would proceed with the facts of this case. Dr. Maya Sarabhai, my client, had sought infertility treatment from Dr. Rohini Lodha and after 4.5 years she spontaneously conceived. On June 10, 1999, when Dr. Maya's membranes ruptured, she was rushed to the hospital. This is a crucial time as rupture of membranes marks beginning of the process of labor. But no senior doctor attended to Dr. Maya at that time. Usually oxytocin is induced within 1 to 3 hours of rupture of membranes if there is no sign of contractions. However, in the present case, Dr. Rohini Lodha on the next morning, that is at about 7 a.m., started IV fluid with 1 ampule of syntocinon or oxytocin to fasten the process of labor. The council would like to humbly contend that the oxytocin given is more than the prescribed limit. Now, reliance is being placed on oxytocin for induction for labor by Jennifer G. Smith and the World Health Organization Manual, Integrated Management of Pregnancy and Childbirth. So that means the reference has been quoted here, madam. The patient, Dr. Maya, who is qualified doctor herself, also noticed the same. Now, further, the council would like to draw attention to your ladyship to the affidavit Mrs. Ratnama K. Nair, sister in charge of Minish Hospital, that suggests that fetal heart was recorded at regular between 120 to 140 per minute throughout the labor, and it never dropped to 80 per minute. But this is considered to be true. If this is considered to be true, then the council fails to understand why at 2 a.m. the patient was shifted to operation theatre for an emergency cesarean section, that is LSCS. And the same is also refuted by the affidavit submitted by Dr. Purnima Dhar, anesthetist, as she says that as there was no acute urgency to deliver baby. In such circumstances, it is beyond the council's understanding to judge why an emergency cesarean was performed. Further, it was induction failure. If it was induction failure, then it should be declared only after 24 hours from the start of oxytocin. Therefore, in the present case, the oxytocin was started at 7 a.m. on 11th of June. Thus, doctor ought to have waited till 7 a.m. on the next day, that is 12th of June. The council therefore humbly contends that Dr. Rohini Lodha decided emergency LSCS because of fetal distress, non-reassuring fetal heart rate, and not by induction failure. It's clear that Rohini Lodha failed to perform emergency LSCS within 12 to 18 hours of membrane rupture. It was abnormally delayed for 27 hours. The baby then didn't cry immediately, suffered from birth asphyxia and seizures. Thus, now placing the reliance on medical literature, it is hereby contended that long hours in labor caused pressure on the umbilical cord and placenta, and that the oxygen supply to the fetus and very importantly to the brain was reduced, resulting in hypoxia. As in the case of Bolam versus Frian Hospital Management Committee, the Bolam principle was established as in the case of medical man, negligence means failure to act in accordance with the standards of reasonably competent medical men at the time. There may be one or more perfectly proper standards, but if he conforms only one of these proper standards, then he is not negligence. Now this is approved by the House of Lords in White House versus Jordan and many other cases. In two decisions rendered by our Honorable Supreme Court, namely Dr. Lakshman Balakrishna Joshi and Dr. Triambak Bapu Godbole and others, this was further applied. Now, in the present case, Dr. Rohini Lodha did not adhere to the duty of care in deciding the treatment and administration of the treatment, defeated the standards practiced by the reasonable medical men. It constitutes the negligence. The principle of res ipsa loquitur applies here also, as Dr. Maya Sarabhai also sought the opinion of doctors in USA from her brother, who is a pediatric surgeon in USA, stated that severe atrophy of the baby's brain cortex and the child might remain severely mentally retarded as long as she lives. So it is the child, that is baby Nishtha, she suffered from cerebral palsy because of this delay. So it was the hospital who was responsible to preserve the CTG tracings. The CTG tracings which were done were not traceable in the Minish hospital. So this is one of the negligence, as the decision in the case of Spring Meadows Hospital and another versus Harjot Singh Ahluwalia is as follows. The very often in a claim for compensation arising out of medical negligence, a plea is taken that is a cause of bona fide mistake which under certain circumstances may be excusable. Now, the counsel seeks permission to put forth the prayer before this honorable forum. It is most respectfully prayed that this complaint be kindly allowed and opposite parties number 1 and 2 and 3 be kindly directed to pay to the complainant the amount as described in para 12 of the complaint. The complainant hereby also seeks relief under section 25 of the Consumer Protection Act 1986 and prays to the honorable forum to pass an order for the enforcement of the directions of the forum. Any other relief deemed fit in the circumstances of the case may kindly be also granted. So,
just now we have the complaint. In the consumer forum, it is summary procedure. In the sense there are no cross examinations allowed. Interrogatories are supplied. म्हणजे जनरली आपण या पिक्चरमध्ये बघतो की कोणीतरी एका घरात उभा असतो आणि त्याला प्रश्न विचारतात वगैरे, असं काहीही फोरमवर घडत नाही. कारण फोरमवर कंप्लेंट जेव्हा तुमची दाखल होते, व्हेन यू फाइल द कंप्लेंट, we are asked them to along with the affidavit and requisite stamp. While admitting the complaint, it is observed whether it is within time limit, that is we call limitation. Secondly, whether it is within jurisdiction, means territorial and my pecuniary jurisdiction. And thirdly, whether it is accompanied by affidavit duly signed by the complainant. If you are hiring lawyer also give the affidavit. And the complaint, after that the complaint is supplied to the defendant answers, that is what we call is WS or written statement, which is always along with the affidavit and all the documents which are. First of all, when the complaint is filed, we require that the complainant must furnish list of documents. These are the very small things, but without that the complaint will not go further. And Consumer Act being a special act, it's a benevolent and very deficiency and diligency for deficiency of goods and services is there in that. So it is quasi-judiciary. Award given by the forum are equivalent to the district court, regular courts, but it is quasi-judiciary. It is not within the purview of high courts. It is to be noted. So now I will request Dr. Patwardhan to give her defendant's answer.
Your Ladyship, I'm Advocate Patwardhan. In the present case, the counsel on behalf of complainant has alleged medical negligence on the part of Dr. Rohini Lodha, but it is humbly contended that Dr. Lodha performed her duty with due diligence and care. She was not negligent in any way, which will be further established by the present counsel. There are three laid down principles to determine negligence. Firstly, there has to be a legal duty of care. Secondly, there has to be breach of the said duty. And thirdly, the damage caused should be a direct consequence of the breach of the duty. In the present case, madam, the complainant, Dr. Maya Sarabhai, was a patient of Dr. Lodha and is thus entitled to a legal duty of care from her. But there has been a breach of the said duty on Dr. Lodha's part. In her affidavit dated 11th November 2003, Dr. Lodha has stated that the complainant was satisfied with her qualifications, experience, and therefore decided to take further treatment from Dr. Lodha willingly. She also attended Dr. Sarabhai as soon as possible after her admission on 10 June 1999 and started the relevant treatment by administering IV fluids and 1 ampule of pitocin, also known as that's the medicine used for accelerating the labor, to expedite the process of labor in the patient suffered from rupture of membranes. But it was noted that the patient was unresponsive to the oxytocin induction even after 17 hours of giving a trial, and so she had a non-progressive labor due to non-affecting uterine contractions and cervical dystocia. She was an elderly primate who conceived after treatment for infertility. I would again reiterate here. Concern for her, the patient's well-being, as well as the child's well-being, Dr. Lodha urged to Dr. Sarabhai to give her the consent for LACS, which was constantly refused by the patient. The delivery was delayed by the patient for 2 hours, even after the precarious case of late conception due to initial infertility, and again the patient's weight was 88 kg, so she was an obese and high risk patient. In spite of all these facts, the patient kept on delaying the consent, and 2 hours delay occurred because of this thing. Also, it is contended by the opposite counsel that the heart rate of the fetus dropped to 80 per minute on the basis of what is noted by Dr. Sarabhai. In her affidavit, Dr. Lodha clearly denies the heart rate being dropped to 80, that is low, which has also been reiterated by the sister in charge who was on duty, Mrs. Nair, in her affidavit. The patient would never have waited for 2 hours to give her consent after being suggested for LACS if such would have been the case. If the heart rate would drop to 80, she herself being a doctor, she would have given the consent at that time. Also, Dr. Sarabhai might have misread the CTG reading in the condition in which she was at that time after rupture of membrane and unsuccessful acceleration of labor. The opposite counsel also has contended that overdose of oxytocin administered to the patient, which led to the alleged dip in the fetal heart rate. Dr. Lodha has admitted she gave the right dose by administering 66 units of oxytocin, which is well within the prescribed limits of oxytocin, and it was given in a graded incremental way, which is as per the ideal way of giving the particular medication. Oxytocin drug per se is non-toxic to the fetus and is a routine practice which is done by all the obstetricians to accelerate the labor. Since there was no response to the oxytocin infusion, which would have led to hyperstimulation and uterine overactivity, there could not have been any fetal distress as stated in Dr. Lodha's affidavit. It has also been contended that Dr. Lodha decided to go further with the emergency LACS due to alleged drop in the fetal heart rate and not due to induction failure. The counsel would humbly contend to that Dr. Lodha acted upon only in good faith in urging Dr. Sarabhai to consent for LACS to ensure that there would be no further delay in delivery of the baby, considering the fetal as well as maternal risk. There was no malified intent to hide any alleged drop in the fetal heart rate as contended. As such, a drop never occurred as echoed by the affidavit submitted to your forum. Also, Dr. Lodha was not negligent in waiting for 27 hours after the rupture of membranes, as the time interval between the rupture of amniotic fluid, amniotic membrane and the delivery of the baby is a different matter altogether from infusion, and depending on the circumstances of the case, the treating gynecologist would wait for few more hours also, few days also, as submitted by Dr. Lodha in her affidavit. After delivery, the baby Nishtha had difficulty in breathing, so all due care was taken and the relevant treatment was given to ensure her well-being, well attended by the pediatrician. Also, there is no correlation between the care during labor and the baby's cerebral palsy. The patient faced certain complications during her antenatal stage also and was advised to undergo few investigations like triple marker test, which would have detected an anomaly element, but it was neglected by the complainant. Such congenital anomaly, if any, could have been detected by the triple marker test and necessary measures could have been taken in the antenatal period itself. After abnormal head growth, which was seen in an ultrasonography, a repeat sonography also was advised after a week, which was again ignored by the complainant. The patient's ignorance on her doctor's advice shows negligence on the part of patient herself. Also, about only 10% of cases of cerebral palsy are are attributable to intrapartum reasons like severe hypoxic events such as acute severe antepartum hemorrhage, rupture of uterus or cord prolapse, and delivery of baby with low Apgar scores of less than 3 or more for more than 5 minutes. None of these occurred in the present case. Thus, Dr. Lodha did not breach her legal duty of care towards Dr. Sarabhai, and therefore was no consequential damages. According to Bolam principle, as laid down in the case of Bolam versus Friend Hospital Management Committee of 1957, a doctor is negligent only when he does not act according to the standard of reasonably competent medical treatment at that time. In the present case, Dr. Lodha followed all due medical treatment and procedures and was sincere towards the patient. She did not act negligently in any way and treated Dr. Sarabhai to the best of her abilities. The opposite counsel has also contended that principle of res ispa loquitur applies to the present case. It is humbly contended that aforementioned principle is not applicable. The opposite counsel has also submitted a medical report by the independent radiologist Dr. Joshi, which contains a CT scan review. It is contended that the report was a manipulated one, as it did not mention the name of any hospital and there is no signature on the report. Also, the report made in USA by Daniel to what opposite party is contending. The complainant has largely relied upon the opinion of Dr. Vijay Karthik that the baby Nishtha's problem were because of negligence during delivery, but there is no certificate or affidavit submitted in this regard. Therefore, the complainant has failed to show any evidence of alleged fetal distress. The complaint has been filed with mala fide intentions without any scientific basis, rather than on the basis of presumptions and allegations which are false and baseless. The course of treatment was explained to the patient during the pregnancy. All management was done as per recommended protocols and there was no negligence on Dr. Rohini's part, and thus it is contended that the complaint isn't maintainable. So the prayer is, it is humbly prayed before the Honorable Court that this complaint is not maintainable and should be dismissed. Any other relief deemed fit in the circumstances of the case may kindly also be granted. Thank you.
Hereby, I am adjourning the court for filing the written notes of arguments. And further, I request Advocate Uday Vavikar to solve all the problems pertaining to CP Act, as he is the best available today for us. So I will not take much time. Thank you very much for listening.